As experts of EU law or as communitaristes, we have been told ever since our first semester of university that the court in Luxembourg is an important player. It takes center stage in famous descriptions of the European project, such as Joseph Weiler's The Transformation of Europe, published 25 years ago. The EU, as we know it today, is partly at least a creation of judges, and the internal market is the prototype of judge-made integration through law. From an academic perspective, however, there was and is nothing quasi-natural in the centrality of the ECJ. In domestic constitutional systems, judges often play a different role, and there are indications that the role of the ECJ may be changing as well. And I'm truly grateful for Iris for having convened that panel. And while I concur with your empirical finding, I do not agree fully with the negative undertones of the title. Why? The essence of my argument will be that there can be good reasons for judges to proceed carefully in migratory matters in light of broader arguments of constitutional law and theory. I will unfold my argument in 3 steps. Firstly, the legal design of the treaties. The specificity of migration and asylum is explained best by way of comparison with the single market, which famously enshrined a specific policy design in primary law. In the single market, the fundamental freedoms endow individuals with a directly applicable constitutional guarantee to enforce this treaty regime via national courts. By contrast, the AFSJ, the Area of Freedom, Security and Justice, establishes competences without telling the EU institutions what to do. They may opt for a generous migration policy, but they are not constitutionally obliged to do so. Instead, the European Convention, drafting today's primary law, laid down diverse and potentially contradictory policy objectives. Combat against illegal migration is one of them. Don't get me wrong. I'm not denying that there are constitutional limits, in particular human rights, but these limits do not undo the principled discretion of the legislature to decide on the road to be taken, within the limits, of course, of human rights. In contrast to EU citizens, third country nationals cannot usually rely on a constitutional guarantee to be admitted to a member state, and the Geneva Convention does not generally prohibit responsibility sharing mechanisms such as the Dublin regulation or the designation of safe third countries. It is important to realize that the Charter also didn't change this overall picture. In the field of migration, the Charter presents itself as a conservative human rights document which principally reaffirmed pre-existing obligations under the ECHR. The court, the ECJ, held as early as 2006 in Parliament versus Council that the right to family life in the Charter does not usually guarantee a human right to family reunification. Luxembourg followed Strasbourg, not its own internal market case law. The same happened with non-refoulement obligations under Article 4, and I dare to predict a similar outcome for the right to asylum in Article 18. The judgment on the relocation decisions indicates that Article 18 does not extend beyond the Geneva Convention. In short, the Charter reaffirms pre-existing obligations, and that is important in itself, but it is, in contrast to the legal design of the treaties in the internal market, not transformative. It's not meant to change things in a different direction. My second section concerns the political institutions. Many of us, and we are a group of predominantly migrant-friendly academics, are often disappointed by what we perceive to be self-restraint or passivism on the part of judges. From a constitutional perspective, however, there is a flip side of this argument. A widespread criticism, not of migration policy, but of the single market or monetary union, is what scholars of constitutional law describe as the over-constitutionalization of the treaty regime if primary law preempts policy choices. Treaty rules on the AFSJ are different. They replicate the standard model of most constitutional democracies by empowering the political actors to discuss and change policies within the confines of human rights. What we call passivism can be described as a constitutional virtue from a democratic perspective. Judges leave room for political choices. That's unusual for the EU, but it's quite common for a constitutional system to do so. The reasoning of recent cases on migration and asylum confirms this finding. The reasoning is defined by what one might call an administrative mindset, when judges focus their argument on the wording, the general scheme, the objectives, and more recently even the drafting history of secondary legislation. The judges read like what we tell our students in the first or second semesters to do, to develop classic doctrinal arguments in the continental European tradition. And this administrative mindset permeates many judgments, as the recent Dublin rulings such as Geselbach, Mengestiab, or Schiri demonstrate. Of course, statutory interpretation need not result in restrictive outcomes. It can advance the rights of migrants, and one legal technique to do so is the doctrine of individual rights, which empowers individuals to challenge domestic rules, an approach the court followed in Chacroun. Many observers called upon the court to follow that example, thereby advancing the rights of migrants by means of statutory interpretation of secondary law, not human rights. It did so in some cases, but it yielded to the legislature on other occasions. To the disappointment of many in the room, the ECJ confirmed language requirements as a precondition for family reunification in KNA, and it granted member states discretion when rejecting students from third states in Ben Alaya or Martinez Silva. Passivism is not necessarily a recent phenomenon. It has occurred for a while. And it seems to me that this mixed outcome is no coincidence. From a doctrinal perspective, the court's reasoning in Chacroun followed, well, the logic of statutory interpretation, which renders it difficult for judges to outlaw national policies which the EU legislature sanctioned more or less explicitly. You could, of course, justify a different outcome if you rely on primary law, but remember, the Charter is conservative, it follows the ECHR. And this brings me to my last section, the disappearance of the treaties. The overall picture need not be as one-sided as my presentation. So far, the constitutional framework of the AFSJ may be much more open than treaty rules on the single market, but that doesn't render existing provisions irrelevant. Indeed, even a conservative human rights instrument can be interpreted or could be interpreted dynamically. Arguably, primary law holds a potential judges have hesitated to unearth. And it seems to me that this silence on the treaties, the silence on the part of judges is an important observation in its own right. The administrative mindset I described a minute ago, which permeates much of the court's reasoning, is accompanied by the lack of constitutional imagination, in particular in the recent asylum cases. By way of example, let me highlight once again the Jafari ruling on the Dublin regulation, which remained largely silent on the constitutional prescription of solidarity in Article 80. The provision is mentioned in Jafari when the Grand Chamber called upon the member states and the EU institutions to react to the crisis, let me quote, in a spirit of solidarity. Note, however, that it is the political actors judges call upon to develop the spirit of solidarity, in striking contrast to earlier invocations of the spirit of primary law in some of the most famous cases of EU law ever, such as Farhent and Los or Lever, in which the invocation of the spirit paved the way for constitutional innovations on the part of judges. Unlike previous speakers, I'm not so much disappointed with the outcome of all these cases. In my view, they were decided correctly, possibly with the exception of the EU-Turkey case. In particular, I disagree with those who think that the doctrinal interpretation of Article 80 would allow us to overcome the deep structural problems of EU asylum policy. But be it as it may, judges, even if they stick to that outcome, judges should have explained nonetheless how to justify the outcome in constitutional terms. We are left, and that's disappointing, with a striking contrast between the judicial emphasis on statutory interpretation, the administrative mindset, if you want, and an almost complete silence on the treaties. In migration and asylum, not differently than in recent EU citizenship case law and the Pringle judgment. And this silence on constitutional law might be rationalized as the result of internal disputes among judges, how to justify a consensual outcome if it happened once or twice, but it becomes a general phenomena when the Grand Chamber repeatedly behaves like an administrative tribunal in cases with a constitutional dimension. How can we possibly explain the absence of constitutional imagination? By way of conclusion, let me just hint at two possible explanations besides the arguments mentioned before. Firstly, judges might feel that it would overstretch the institutional legitimacy of judges to decide questions which are extremely salient in the domestic political context. Migration can have important and visible economic, political, and cultural repercussions. You can lose election for migratory events. And to rule on the relocation of refugees is not the same as an innovative judgment on the technicalities of the single market rules. Judges might simply feel not powerful enough to do that. Secondly, it might be illusionary to assume that judges alone are able to develop constitutional values, such as an enhanced level of refugee protection beyond the confines of the ECHR. Innovative constitutional jurisprudence needs to be embedded, arguably, in social practices and political processes if it doesn't want to remain a hollow hope, to cite a famous American political theorist. Constitutional values cannot and should not be realized by judges alone. Indeed, the very term value is a term which hints not only at legal effects, but hints at a broader social and political embeddedness. And it seems to me that this need to embed EU law, to embed constitutional values into broader social practices and political events is one of the core lessons of both the constitutional treaty, which failed 13 years ago, of the Brexit referendum, and of the refugee crisis. If we want EU asylum policy to thrive, if we want values to develop, we cannot rely on judges alone. That would be too much to expect of them. And for all those who want to learn more of my argument, feel free to consult my case note on the Jafari and Mengelsterb judgment, which will be published in the Common Market Law Review shortly. Thanks.